judiciary exists for the people of Kenya. Approaching it from that principle, I do not see anybody not being unable to have a dialogue, because I am not doing this for self, but I'm doing it for the people of Kenya. Understood in that context, and since all the persons that we are talking about are, number one, patriots of the highest order, leaders of the highest order, I should be able to have a structured meeting with the three arms of government at any time. And I repeat once again, it's not benevolence, as Adam Smith in this book of Wealth of Nations says, but something for the common good of the people of Kenya.
I'm grateful, Senior Counsel, for having answered those questions, and would have no more. Thank you very much. Thank you.
Thank you, Attorney General.
Thank you very much, Madam Chair.
Thank you very much, Honorable Attorney General. I will now request Commissioner Patrick Gishohi to ask his questions.
Thank you, Professor. Counsel, good afternoon.
Good afternoon, Commissioner.
Very good. I want us to focus on something different. You have spoken very eloquently about the Judiciary, the Court of Appeal, the Supreme Court, and all those issues. I want us to focus in one key areas as you come in, if you get this position, and I pray you get it, as the chairperson of the commission. And I want us to remain on the commission itself.
This commission.
This commission. As soon as you get to the office, the first thing that you'll be able to get is a report by the consultants that was submitted to this commission, I think in 2019. In that report, it's about the review of the organization in terms of its operations. We are at the stage of implementation. As the chairperson of the commission, we have raised two issues that I would wish you to reflect on. One, governance efficiency of the commission is below average. Efficiency of the governance structure of the commission is below average. Two, weak performance management system, among others. That report will be on your desk if you get this position. Will you share with this commission how you address those two issues that are very prominent in that report by the consultants?
Commissioner, not being privy to what led to such low grades, because these are very low grades, not being privy to what happened for you to be below 50%, I may be a little hard-pressed to say what prescription I'll come up with. But I can say this. As a Chief Justice,
Chairman of the Commission,
and Chairman of the Commission, I will not only look at the report, because the report is the end product of a process. I will start off with where did we start doing things the wrong way. Because to have a grade that we are below average is an embarrassment to all of us. But there may be concerns and interventions that were not done at the right time. So I would want to see why didn't we do those interventions early enough? Why is our performance weak? I would want to see as many of those reasons as possible. And again, working with this commission, instead of us now saying how awful we have been rated, I will actually roll up my sleeves and say, look, ladies and gentlemen, we must get to over 90% at the next assessment.
Honorable Counsel, that's what I'm looking for. The instruments that you are going to put in place to take us to that level, as our leader, as a commission, as the chair of the commission, if you can be able to share with us one or two issues that you do to take us to that level of 90%.
That's what I indicated. I would want to know why we went to that low level first. That's the first port of call.
Yeah.
Because when you get a result, Commissioner, a result that is 40%, you may not be able to prescribe what is wrong without understanding what led to the 40%.
Okay.
So the first tool I'll look at is our history. When was the last assessment done? What has happened in the intervening period? And what is it that we didn't do correctly?
Okay.
Yes.
I think, Senior Counsel, what my colleague is looking for is a hypothetical indicators. You know, I mean, if you are to assess, in your opinion, what would be assessed, even if it's hypothetical, you must have an idea of what would be assessed.
I see. I'll look at the leadership.
Leadership?
Leadership would be one of the things that I'll look at. I'll look at the collectivity. By collectivity, I mean, what are the other members' input or lack of input into that leadership? I'll look at the implementation. Those are some of the things that I'll be looking for.
Okay. I'm sure you have looked at the kind of structure you have the commission. And you're talking about the mechanism of making sure that the commission is accountable. Yeah, earlier on, you talked about accountability in terms of the members, in terms of the staff. I would like to hear from you, what mechanism will you put in place to ensure that the commission remains accountable in terms of the structures?
I'll put every measure in place. I will, number one, look at the regularity of the meetings, the agendas set out in the for the meetings, the way we transact our business, and more important, Commissioner, as you know, it is also the follow-up and the implementation of the decisions.
Okay.
So that if you have a weakness at any one of those levels, then you are not able to fulfill your constitutional mandate, which is set out in Article 160. It is 171. You know, you have a constitutional obligation.
Okay.
Yes.
Let's take the case of the staff. And you have to ensure that your staff remains motivated, productive, and efficient. We have human resource manual. We have policies that govern human resources. I would like to hear from you, as the chairperson of the commission, what programs you put in place to ensure that the staff are productive, efficient, and their performance measured?
Yes. One of the things I think in every large organization, not large, it's all organizations, is a bit, you've got to look at staff welfare.
The staff welfare, yes.
And there are certain very quick wins that you could have with staff welfare. Look at a medical scheme, for example.
It's in place.
Medical scheme for staff is one of the things that is very endearing, particularly when you have staff who are young, of childbearing age, and with young families. That becomes almost a must-do, because you reduce the stresses associated with taking a child to hospital and then the money required. If we can have a staff medical scheme and make sure that at all times it's valid.
Okay. Talk a little bit about reward and sanctions as far as human resources is concerned in terms of the judiciary.
Yes.
Yes.
Reward
and sanctions.
Yes. Reward is something that is very nice, and it's been tested in a few blue chip companies, where you can have performance indicators. If you go beyond this performance level, or you achieve this, there will be a reward. And it's something that people look forward to. And a lot of blue chip companies all over the world have reward schemes, and of course they have sanctions. Because you can't just have reward. If you do not achieve to your target, there should be a sanction.
Okay. The other question that maybe you need to discuss is the issue of financial accountability. There are three words that you normally use in public service: source, spend, and account. As the chairperson of the commission, the buck will stop at you in terms of financial accountability. Would you expound a little bit on source of the funds, spending on the fund, and accounting for the funds? What will guide you?
Yes. I'll be guided by the law as always. The source is really no other than National Assembly.
National Assembly.
I will do everything possible at the earliest opportunity to engage with the Budget Committee, as you are aware, as a former very resourced person in it. You start off at the Budget Committee, you go to the Justice and Law Committee. Equally important is the Speaker of the House.
Okay.
And then from there you go to National Treasury with the Cabinet Secretary, so that everything is done. But allow me to say this, Commissioner. It pains me to see that the Treasury Fund has never been made operational.
We are coming to that.
Ah, good.
Go to the next spend. You have sourced the money?
You've sourced the money.
Yes.
But you see, you can source the money and it's a budget item, but it's not been given to you, which therefore means CRJ has got to make endless trips to Treasury for releases which are done piecemeal. That in itself becomes a problem, because then the spending, you may not be able to absorb it.
Okay.
And this is one of the things that I found out when I was doing the Council of Governors case, that a county is given funds in June, you can't absorb it. So absorption levels are so low, 10%, 30%. So depending on your question about Judiciary Fund, if our funds are given like for consolidated or equalization, then our spending becomes, we are able to absorb up to 98% or 100%. Accounting is the
Now,
one.
before we come to Accounting
Sorry.
Council, Honorable Council, my interest is the chairperson of the Commission. When it comes to spending the money, what is your law?
The buck stops with me.
Yes.
Although I will not micromanage on a day-to-day basis, we must have very clear, very clear spending parameters, what we are spending it for. If it is for construction, it's clearly earmarked. And these are not things that you just simply assume they are being done.
Okay.
Yes.
I want to hear from you. What do you expect to get from your accounting officer as far as that spending is concerned?
Very well. I would want to see a budget.
The
key
budget
one
is there already?
Is budget. Number two, we have been allocated so much. What are we going to spend it for? Number three, the procurement processes.
Procurement.
Because if there are no procurement processes, then you are dealing in darkness.
Okay.
And you can't fly in blindness.
Let's go to accounts.
Yes. The account, we owe it to the people of Kenya to account to them. The annual report, the annual report that is generated, it is a legal requirement. We must table it to Parliament. And as a matter of fact, that is a document that shows what we have been given. We have accounted for it to the last cent.
Okay. Let's go back to the Judiciary Fund, which is actually, it has been enacted, you have the regulations, but we are still not there. Now, as the chairperson of the Commission, I'm very interested in terms of the operation of that fund, and in terms of your strategic partnership, what will you do to at least to ensure that that fund gets the money that is in operation?
As I was preparing for this interview, I took some time to understand why what is as obvious as day follows night has not taken place. And one of the things I saw is that there's an argument about the Public Finance Management Act requiring this and requiring that.
Yeah.
Being a lawyer more attuned with the Constitution, I will engage the other stakeholders.
Specific stakeholders?
I will engage National Treasury.
National Treasury, what level?
Sorry?
At what level is the chairperson of the
CS.
Commission?
CS.
CS, yes.
Speaker of the National Assembly. I don't know who other person is. Maybe the Auditor General. I also saw there is a reference to Auditor General. And whoever other is key person is a key impediment to the act being operationalized.
Okay.
And I would want us to understand
Yeah.
that Judiciary Fund is no less than Equalization Fund.
Oh.
And they are set up by the same constitution. So let us not play statute law as a way to impede judiciary to have financial autonomy.
Okay, Council, since you have talked on that issue, if you look at the Constituency Development Fund, at least they allocated 2.5% of the revenue. Now, in terms of the judiciary, we are not yet there. I would like to hear from you as a chairperson of the Commission, and with all those other strategic issues that you have, how do we ensure at least we are very clear, we are predictable, and you know that at the end of the financial year, we either have 3% or 1% or 5%, so that when you are budgeting our programs, you are certain that the money is going to be there.
Yes.
How will you do that?
Yes, I would agree with you, Commissioner. It will be very good to have a degree of certainty what your allocation will be. And I've seen in one or two papers of a suggestion of 2.5% of the annual budget. How will I get there?
Yes.
Is the same way I indicated. I will engage with other players in it. You see, I think here, and I believe, Commissioner Gishohi, you can understand me. Sometimes we react to a situation which has already happened. And I've seen persons going to complain to Treasury after the budget speech has been read. I mean, as your commissioners are aware, budget making starts in August. So in a few months' time, the budget making process for next year will kick in. And there will be a minister's speech. After that, there are so many key statute procedures that immediately start. So if you wait until the budget day and say, look, I wasn't allocated, it's far too late.
Okay.
So I'm sure I'll engage with CRJ, with the other directorates, and we'll engage National Assembly, if not August, earlier than August.
Okay. Let's go to something else. Devolution. What place do you see the judiciary in terms of our devolution process? And when you're discussing that, if you are invited at the summit, he brings together the national government, the county government, the president as chairperson of that summit, and you are invited in that summit as the Chief Justice. Could you share with us two issues that you would be able to articulate on behalf of the judiciary in terms of justice delivery in our counties?
Yes. Having worked for the Council of Governors, again, I see that as a seamless exercise. I will request the county governments to be quite ready and willing to allocate land to judiciary.
Like allocate land, yes.
Allocate land to judiciary for us to construct courts. They may not be the mammoth structures of high court. They may be as simple as magistrates' courts. But the beauty with that is this: we have a constitutional obligation under Article 6 to take our services as close to the people as humanly possible. That is a constitutional imperative. So, Council of Governors or governors should not expect us to go to the marketplace to look for land and buy land. They have lots of land. We are doing this for the people within their counties. And I would expect a very, very easy, seamless interaction with all the county governments.
Apart from land, what else?
That is what I would immediately expect. Then, needless to say, I would expect that if we are constructing the court, they will be our partners, will educate our people, they will help us educate their people of the need to access our services, and more important, the need to be partners in our courts as users and as beneficiaries of our systems.
As a person who lives, some of us, in our rural areas, Nairobi appears very distant. And most of the services that are sought by our Kenyans are up there, 90% in our rural areas. And in terms of settlement of small cases, small disputes, we have very big challenges. If you become the Chief Justice, I'd like to hear from you in terms of the establishment of these small claims courts. I do realize that you did allude to that earlier on. But I want to be very clear. Will it be part of your first agenda in your platform?
Yes. Because small claims court, Commissioner, are a win in many ways. Currently, the backlog that I think we were discussing with your colleagues, the backlog in our system are those claims. Claims of 500,000, claims of this. These are the kind of claims that could very legitimately be transited to the small claims court. So it is actually a long overdue activity. If it could even be implemented tomorrow, all the better. And immediately you see from a case backlog of, say, 200,000, you may reduce that by 100,000. So this backlog is something that needs a very comprehensive view. Because if you take, say, 100,000 cases from the magistrate's court, then you free them to deal with the cases which are beyond the pecuniary jurisdiction.
So, Counsel, you're saying that in case you get this position and within 100 days, still be allowed here, God willing, we shall be able to see this small claims court on and running?
Immediate. They should be immediate.
Okay.
They should be immediate. As quickly as humanly possible.
Okay.
And they are not difficult to do,
Okay.
as I understand it.
Before I go to my final question, I want us to look at communication strategy. You see, communication is very, very important, both internal and external. And if you don't tell your story, somebody else will tell your story. If you get the position as chairperson of the commission, I would like to maybe share with us 2 steps that we want to take to enhance our feasibility, our communication with our stakeholders, both in government and also the public. Communication strategy.
The communication strategy starts from what is our mandate. And since we know what our mandate is, we know who we are addressing our communication to. As to whether we have a web page or whatever, those are details that one can work out. But as you very rightly say, we must tell a story. What is JSC doing? For example, you have done so much in employment of judicial officers. I can't remember what numbers they were in 2011 and what numbers are today. I think for judges, today they are in excess of 150. For magistrates, there are so many. That story is not told. And yet it is the achievement of JSC. You have done wonderfully well in even disciplinary cases. Again, that story is not told. These are things that JSC, again, must bring sunshine. Because you don't want to be seen as a moribund institution that doesn't do anything, when the truth is, you have done so much.
All right. Let's talk about ethics. And I read a lot from what you have written up and other issues and the way you are described by your referees. And I want you to focus on what we call personal conduct for individuals and a kasha, a corporate kasha, the kind of kasha that you like to see the judiciary have, corporate kasha. Would you be able to share with us? Corporate kasha, values.
The corporate culture I would wish to have to see in judiciary is, number one, sensitivity.
Sensitivity.
Let me explain to you why I picked that as number one. Being a Kenyan, I think I was horrified when I read the story of a gentleman called, I think, Murage Murage or something like that, who had smuggled his little infant from Kenyatta National Hospital in a paper bag.
Yes.
And what we did as judiciary is open a file for him and give him a suspended sentence of 3 years.
Okay.
That is not what I would want to see in judiciary. We must be sensitive because that gentleman, all he required is intervention, not even at our level, but at a public national referral hospital.
Okay.
So sensitivity is very important.
2,
Number 2, it is accountability.
accountability culture. Yes.
We must be fully accountable.
Accountable.
We should get out of that era of giving judgments which are incomprehensible, giving ex parte orders that persist forever, where we now see that we are responsible and accountable. Whatever we do is for the betterment of the common good.
Okay. Just before I finish, you are at liberty to answer this question. We have crimes or offenses that are across the borders or international crimes. That if you commit this offense in this country, or other countries that we know we have agreements can actually get hold of you. We had some cases, I think 2 or 3 years ago, some cases that have been going in here, wildlife offenses, drugs, if you can call it. The drugs in our courts for, 10 years and the rest. And when those people appear in those other areas, within 3 months, or less than 3 months, those cases are concluded and finished. I know you talked about delayed judgments and the rest. I want to be very clear. What one thing do you do to ensure that internationally we are seen to expedite our delivery in terms of the cases that come to us that affect even other nations?
Even the crimes that don't affect other nations, even the crimes that just affect us. For example, public looting of funds. Those just affect us to a large extent. In all those cases, the penicillin for it is this: quick disposal of the cases. But when the cases are held at the are not to be resolved in the near future, then you see somebody is delaying and doing all manner of things, and that is I know the case you have in mind. You go to a different jurisdiction and you know that you have a hearing next month, just like Floyd, the case I think Commissioner Macharia was talking about, and you know that your lawyer is not going to say that he had a headache the day before, because for the simple reason the hearing will go on.
Okay.
So that is the whole idea. And when Costa Rica did this study, and it was an empirical study, they actually found a complete relationship between quick hearing of criminal cases and reduction of criminal activity.
Finally, Madam Chair, this is my final question. When you answer the question from the Honorable Attorney General on corruption, I really appreciate that. I wanted to hear from you, both internal and external, perception or otherwise. Do you believe that there are some cartels that you need to clear from courts that are actually hindering service delivery, justice?
It is possible. At the same time, it may not be correct. So, what I can promise this commission is this: I hold nobody's brief. I'm my own man. I'll come and do what I've been known to do. What I am, Commissioner Gishohi, is hard work.
Hard work.
It's just hard work. Okay. And I'll come, if there are cartels, let them know as soon as I'm sworn in, their days are numbered.
Thank you, Chair. Thank you, Counsel.
Thank you very much, Commissioner Gishohi. Thank you, Senior Counsel. Senior Counsel, when you asked the question about the source of funding, I heard you talk about exchequer. Would you try to get money from other sources?
Ideally, Prof, ideally, a judiciary ought to be funded by the government. Ideally, we should be a bit hesitant with external donors. But when need arises and we need external donors, I'll be the first one to seek their assistance. I must also say, in whatever activities that I'll be thinking of, I'll of course also want to work with civil society. There are some civil society groups that are of wonderful influence, who have wonderful literature, and it will be best we work with them. We are foreign donors, yes, but ideally, let's look at Wanjiku to be the person to fund us because we are here for her.
Thank you, Senior Counsel. Next is Honorable Commissioner Koskei.
Thank you, Chair. Good afternoon, Senior Counsel.
Good afternoon, Commissioner.
Yeah, I'm going to pick up from where Commissioner Judicial left, but I want us to look back, 10 years back. And the happenings that took place. Are there happenings that you can identify, 2, 3, 4, that will inform your administration in judiciary? Besides COVID, of course, is one, the pandemic is one of the happenings that may inform your administration, may shape and inform your administration. What other happenings can you recall that can really mainstream and shape the administration of Chief Justice Ngatia?
One is independence. Without independence, there is not much success you can have. I would want to be a Chief Justice that anybody in Kenya is very comfortable going to his court. Because in that court, they know that the justice of the case will be looked into. I would hate to be a Chief Justice where any segment of people are uncomfortable with my court.
Senior Counsel, I want us to have practical examples of what has happened in the last 10 years that will inform.
One of the practical things I thought is lack of independence, because that was...
Is there any situation, is there anything that you saw that happened that you seem to believe that it was because of lack of independence?
Yes, as you recall, in 2008, a candidate refused to come to our court and opted to go to the streets.
Okay, so that is one.
Yes.
Next. What other? Yes.
The next thing is that I would want, or I would look for judges who have fidelity to their oath of office. Fidelity meaning that really it is the case and the case only that will guide their decision.
Yes.
I would want to have the finances of judiciary ring-fenced.
Yes.
And the beauty with having judiciary funds ring-fenced is we don't need to be going to Treasury every now and then, because by doing that we'll never be able to achieve our objectives. Mm-hmm. So if we could have our revenue ring-fenced, then we are able to budget for it, to plan for it. That way we are going to achieve our year's planning and whatever we intended to do. And I'm sure in this, Commissioner, you would agree with me, there's no point of us getting budgetary allocation a month before the end of the financial year. We would want to have this right at the word go, and that is what the Constitution expects.
Yes.
Yeah, and those things, particularly the last one, it's not just the last 10 years, they are still happening to date.
Any other?
I think those would be the ones at the top of my mind.
Okay, thank you. You've said that you've been a consumer of judiciary services, and you've practiced across from magistracy courts, high courts, up to Supreme Court. And you must have, you must be one of those who have experiences, who can tell how judiciary operates. And I wanted us to focus on customer service. The public more often complain that judiciary is not good in terms of customer service. Long turnaround time on payment of fines, refunds of bails, and several other services that would ordinarily be, instant. But when it comes to judiciary, they say it is it becomes very complicated, even to have a customer service desk to direct people is a big problem. So, as a consumer of services of these institutions that you are now planning to come and head, what challenges have you faced as a consumer of services, and what probable solutions are you bringing in to sort out those challenges that you are facing as a consumer yourself?
Yes, Commissioner, you've hit the nail on the head. Some years ago, and we can talk about this openly, you'll be given a bail of so much amount of money, but I think it will be so deliberate that since the file is still with the magistrate, you can't pay the bail. And ultimately, you end up being in remand, not because your relatives didn't have the bail money, but because of inbuilt, insensitive processes within the court. That has largely become a thing of the past. Not that we still have room to improve. Look at the fines or the refund of the same bail. You are acquitted of the offense. Your 500,000 has been with judiciary for the last 20 months or whatever. To get it is another laborious exercise. In my view, it should be as simple as a cash or at a bank account. You have the acquittal, is in the court file, you have your original receipt, you have your ID, you should be able to get it instantaneously. Why are we still operating a very archaic process of making somebody go to the cash office for countless number of days? These are things that we should work with very, very quickly and see what processes and what interventions we require to do. And really, it's a question of, we go back to sensitivity, to sensitize our own people. A desk at the entrance of the court, and I see this happening in a few courts, a customer care desk, and just telling people, your court number 1 is this side, court number 2 is this side. It may appear very small, but Commissioner, let me assure you, it's the biggest thing that would happen. I'm sure you have traveled overseas. To be met at the airport makes all the difference. The consumer, our Wanjiko, is coming to Kibera Court for the first time. She has no idea where court number 6 is. If we have an attendant to just tell her, Wanjiko, you go to first floor, turn to the left, that is court number 6. That cost nothing, and that really is a wonderful face of the judiciary.
Thank you. Now, judiciary has been blamed and has been blamed that it is a threat to economic growth. Even last week on Friday, there was an article on one of the newspapers by Nganga Mbogwa, who, I quote, Kenya will perform poorly unless JSC picks a person who thinks business, even as he or she ensures the wheel of justice continues to grind. And judiciary seems to require now a head who will come and think business, who will work closely with the executive in terms of ease of doing business, who will work closely still with legislature to ensure that this country becomes attractive to investors, and thereby, creating, jobs for our youth, and at the same time creating wealth. What is it that you are bringing into judiciary that can really help in transforming our way of doing things to the extent that it will be a destination of choice when it comes to investment?
Apart from investment, let's look at the broader picture of economic growth, because I'll also deal with investment in a minute. It is true, because of the way judiciary has been doing its business, and doing its business is a case is filed, it is processed. We never take the effort to look at how much we are locking up in that file. Look at it without again mentioning names. If you are to look at the estates locked up in controversy for the last 30 years, estates of deceased persons locked up in controversy for the last 30 years, is billions and billions and billions of shillings. It takes very little effort to see how you can unlock that wealth. That's number one. Equally, in commercial disputes, and I'm here, I would wish to say the commercial division of the High Court has done so well. They're trying to unlock the cases which are locking up lots and lots of money that would otherwise be freely in the circulation. Yeah. Commercial destination, yes. We can be a commercial destination, but we must also do what we are supposed to do. We must make our law productive and an incentive to dispute resolution. The minute we keep on a flip-flop, whether arbitration is final or not final, will never be a good investment destination. Any investor wants to look at a country that, if I have a dispute, I go to arbitration, because in arbitration, the beauty with it is it's a commercial decision being made. You don't want to be remembered for posterity about a very refined legal argument. So Kenya must make a very deliberate effort. Are we going to have arbitration as insulated from judicial intervention? And if we do that, then we can go to the next level. Have an arbitration center. I'm sure the Honorable Attorney General is very busy on trying to create an arbitration center. But that center will not attract business until the other level, the other tier of is arbitration final concluded. And if we do that, you find actually foreign investment is coming quite easily. And even for us as local people, you unlock a lot of wealth, which is now locked up in unnecessary court cases.
So what solutions are you going to give? Can you break it down and
go
direct to...
I'll break it down.
Yes.
For family division, all the people who have had their estates locked up before the lawyers who are now acting for them, before they were born, I'll allocate 1 or 2 or 3 judges to hear those cases to conclusion, because that is so important. We cannot allow that we are now going to the 4th or 5th decade after the departure of the testator, and those cases are still locked up in controversy. I'll do everything I can to resolve this issue of arbitration, because once we resolve it, then the executive will be able to set up an arbitration center, and that will be an attractive investment to foreign investors to come and invest in this country. A lot of it rotates around what we want to do. And all the time, unfortunately, Commissioner, we go back to Singapore. They had all these things that they could do. Why did they do them right? They did them right because they took a bold step and said, on this is the way to go, and they went for it, and now even disputes are being taken to Singapore.
Thank you. My final question is on community service. I've seen that you're really busy. You involved yourself more and more on community service, right from home to Nairobi. You are even supporting a hospital and chairing even the Alamano Center construction. What drives you? What motivates you in focusing more on community service? Is it because you are running away from conspicuous consumption, or what is it that is driving you towards that direction?
I'm not running away from anything, Commissioner Waziri, at all. What you see is really the same person from January to December. It is not a hospital, it's the hospice.
Oh, yeah.
Hospice is a center for palliative care for the terminally ill. I support them wholeheartedly. I'm very, very close to them. I work programs with them. You'd be surprised, Waziri, for 50,000 shillings, that would be enough palliative medicine for 1 or 2 patients for the next 2 to 3 months. I look at it because I share in the divinity of every human being. We are all one people. And it's very easy to forget our brothers and sisters in the hour of need. When we do that, we lose ourselves. We are united as a people. We are united in times of distress. So I do a lot of work for them. I am a practicing Catholic. Currently, I'm the chairman of Kamwenja Teacher Training College. I was requested by the Archdiocese or the Archbishop to do that work. I am doing it because a request from my Archbishop is really a mark of trust. I'm currently renovating our chapel. We are about to get the diploma teacher trainees, maybe in 2 months' time. I decided to renovate the chapel, and I do so many other activities at home. I'm the patron of my parish in Nyeri, and I do so many other activities. Am I running away from anything? Far from it. I do believe that we have a common destiny and a common humanity.
Thank you, Senior Counsel. Thank you, Chair.
Thank you, Senior Counsel. You talked of Nyeri. Is that your home county? Because I should have asked that from the beginning.
Yes, you didn't ask.
Yes,
could I take this opportunity?
Yes.
I was born in Nanyuki. I went to primary school in Nanyuki. I saw Ole Kapalo, who was a big boy at Nanyuki Secondary School. I was so impressed by his skills. I then applied to join Nanyuki Secondary School because of Ole Kapalo. He was more or less a mentor to me. It's after that I went to Nyeri High School. And may I also say this, because some of these things need to be said. A lot of boys in Nanyuki Secondary School, as Professor, I'm sure you may be aware, the catchment area is like Kipi, a bit of Nyeri and Aberdare. These are the areas that had been ravaged during the independence struggle, ravaged to the bone. So a lot of the parents did not have the means, but we had a very good bursary scheme founded by the first president, and most of us, including myself, our teacher or the person who paid for us is the bursary scheme. You went to the district education office. If you had good grades, and you had been appointed to a government school, or you had been admitted to a government school, there will be a bursary. But as you remember, maybe you may not remember, Prof, school fees was something like 450 for the boarding school and 250 for the day scholars like me. So with a bursary of 200 shillings from the district education office, we were able to go through our education. So I am forever grateful to a safety net that was created by the first president, because that is the one that enabled a lot of boys in Nanyuki Secondary School to see the end of secondary school. As we were going to A-level, school fees for A-level was abolished, again by the first president, so we were able to do A-level without any tuition. University of Nairobi, there was a scheme which was the boom, which we used to get every term, and for which I have repaid to the full cent. So to a large extent, good processes, good procedures in government are able to see even those who are not endowed go to the highest level in life. So for any young people who are listening to this, it is possible with hard work, with perseverance, to aim for the very best. Kapalo and I are united in saying it is because of those timely interventions that we became what we are today.
Thank you, Senior Counsel, for that additional information, so we can record your county as, is it Nanyuki or Nyeri?
I'm born in Nanyuki, that's my county of birth, but my ancestral home is in Nyeri. So I'm owned by two counties which are next to each other. So I cannot denounce my ancestry. I do a lot of work in Nyeri because that is where my ancestral home is.
Which county is in your ID, Council?
Laikipia.
Also, I don't know what to record. Is it Laikipia then?
I think we go by the home place I was born is Laikipia.
Okay.
Yes.
Thank you. And your name betrays you, so we record your Kikuyu by ethnicity?
Yes, I am. Although I should be more of a Kenyan, but I'm a Kikuyu by that tribe.
Yeah, we asked this question, Senior Counsel, because of the requirement of taking care of diversity. I'm sure you're aware.
Correct.
Thank you. Yeah. Lastly, now is the turn of Honorable Commissioner Evelyn Orwade to ask you the last set of questions. Commissioner Orwade.
Thank you very much, Chair. Good afternoon, Senior Counsel.
Good afternoon, Madam Commissioner.
I have a few follow-up questions before I ask the questions that I had for you. I'll start off with, Columbus is said to have discovered America, even while the Red Indians were in it.
Yeah.
In the insider-outsider debate, you've described yourself as an insider and not an outsider. And I think you're entitled to your opinion. But you set yourself apart, if I understood you correctly, when you drew the analogy of the Chief Justice who put an end to racial discrimination. Essentially, your message or your point is that you bring in a fresh perspective. Now, I've been listening to you, Senior Counsel. You have quite well put the ailments that belabor or beleaguer this institution. But your interventions, most of what you have said, is what is already happening in the institution. You've spoken about accountability of individual judicial officers. We already have the daily court returns that we file on a daily basis to account for the work you've done on a given day. You spoke about a cashless system, which is already up and running. You spoke about identifying some judges to concentrate on backlog. We already have that in the form of service weeks. You've spoken about automation. We're already rolling that out. You've spoken about inculcating ethics and values. We are forever attending trainings, are forever going on retreats, basically doing just that. On motivation, you spoke about a medical scheme. We already have that. So what I'm wondering is this. What is the fresh perspective, the innovative strategy, the practical thing that you bring on board as Chief Justice Ngatia?
Number one, I think, Commissioner, I didn't describe myself as an insider. I said I am a user or a consumer of the services.
I stand corrected.
Thank you. Not that it's wrong to be an insider, but I never got the opportunity at the right time. Alternatively, I was not available at that time. In my first 100 days, I would have the equivalent of JT, Judicial Transformation Framework that Chief Justice Mutunga did. I have already identified what I'll call it. I'll call it expeditious disposal of cases. In that blueprint or in that transformation agenda, I'll be able to come up with pillars of what, with your assistance, we hope to be able to be transformative. True enough, there is access to justice. True enough, I concede that. But access to justice has two elements, qualitative and quantitative. Access to justice has also certain drawbacks. You may build a court, which we already have done in Nyeri. Are we content to say there is access to justice because of that court? I'm looking at the next development, which is an expedited delivery of the court cases in that court. So I would go on record as saying this. Very nice framework policies are in place. Fantastic. But we need now to refine them and to see out of those framework which are the areas we can take to the next level. In those framework, expeditious disposal of cases is not given the prominence I would wish to give it. I would wish actually to come up with a timetable of from filing to conclusion, what period of time are we talking about? I know about backlog, it's there, we are doing everything possible, but we can do much more on that backlog. We can reduce the cases in the courts, magistrates' courts, by having small claims courts. And those small claims courts may take a huge bulk of the backlog of those cases. So it is not something I would have done, a transformation agenda I would have done as a practitioner, because I would not be able to have access to the full range of the literature which you have and which I don't have. But I can say that I'll be able to work on that, and with the effort with the participation of all the other players, be able to roll it out within 100 days. I think that's what Chief Justice Mutunga did, Chief Justice Maraga did, and that is what I'll be able to do.
And Chief Justice Maraga also gave a time frame within which he had hoped we should be able to deal with backlog of a certain number of years.
Correct.
Yes, so I take it that what you're bringing on board is basically to refine what we already have in place, the strategies we already have in place.
And to improve on it. Not just to refine, but to improve on it and to bring maybe another dimension or another angle of resolving it.
Okay, thank you. I think another thing I want to say on the issue of backlog, not necessarily as a question, but just to set the record straight over something you had mentioned earlier about dismissal of dormant cases.
Yeah.
You mentioned something to the effect that it's like running away from the problem. I just feel the need to correct the impression created, because it is true that on many occasions, Kenyans will rush to court with their cases. Somewhere down the road, maybe because of intervening circumstances, they choose to abandon those cases.
Yes.
So I think it's a very useful strategy to do away with dead cases in our registries, just to set the record straight.
Could I please?
You wish to comment on that?
Yes.
Okay, feel free.
And here I'll start guided by my Lord Judge Majanja. I think a lot of cases, particularly in commercial, are won or lost on applications. So I would agree with you. If somebody goes to court, commercial division does not get the injunction to stop a bank from realizing the property, and the property is realized, the chances of that person going back to court are almost zero. So you are quite right. It's the procedure in which we invoke to get those dismissals. If we do dismissals summarily, then what they do is they provoke applications for reinstatement. I'm in agreement with dismissals, but we must be with due process. And sometimes I think in a service week, there's a service week, I remember I did a bit of looking at, not really research, but from that service week there were so many dismissals, and the following week there were so many applications for reinstatement. So it's a question of how we do it, and we do it correctly. But at the end of it all, much as we do dismissals, there are still those cases that we must handle.
Okay, I've heard you on that point. Before I ask you the next question, Senior Counsel, I would wish to ask you, how many associates do you have in your law firm?
Currently, because of what we are going through, I have 3 other lawyers.
3 lawyers.
We upscale as depending on the type of engagements we are involved in. I have led teams of up to 30 and 40 lawyers. I upscale depending on the activities. Currently, as of today, I have 3 other lawyers, so we are 4 lawyers.
Okay, thank you.
Yeah.
Senior Counsel, in my view, you put it quite aptly when you said that the most critical of the Chief Justice's role is to be the head of the judiciary. And you must agree with me that the dynamics in leading a team of, say, 10, 20, 50 lawyers is different from the dynamics of leading an institution, an arm of government that has over 5,000 judicial staff, slightly over 500 judicial officers, and about 200 judges. In your experience, or what you have experienced in your legal life, do you think you are well equipped to handle that kind of responsibility?
Yes, Madam Commissioner, as I indicated, the tools you use to manage Safaricom with so many millions of subscribers are the same tools you'll use to manage another company with a fraction of those subscribers. Consequently, we cannot set as a must-have done somebody who has managed, say, 10,000 people to be the only potential CJ. All over the world, Kenya included, we've had CJs who have not had any leadership of an institution. The most pronounced Chief Justice, Professor, is in prior 2010, is Justice Madan. Any Kenyan would remember Justice Madan. Judge Madan was just a judge. Never ever did any administrative work. He became the most pronounced and the most remembered judge in the history of Kenya, closely followed by somebody like Justice Apalu. Justice Apalu was just a judge, and he was appointed a Chief Justice, had not even run a registry of 2 people or 3 people. Those 2 justices served for a period of 2 to 3 years. They left a mark that is everlasting in this country. I do not think, in my humble opinion, that a person who has had an administrative or task force of so many people will make a better Chief Justice than one who has not. And you can check this across the world. But we don't even need to go further. Kenya in itself is a wonderful example. And starting off from the first Chief Justices, and I'm sure here Commissioner Attorney General has a better history than I have of the Chief Justices who are well remembered and who had not ever held any administrative task in this judiciary.
Thank you. Thank you for your response. Now, moving on to the questions that I had. What is the position of a prospective parent in a surrogacy agreement when it comes to rights, parental rights and responsibilities?
Please say that again.
The position of a prospective parent in a surrogacy agreement in respect to the rights, parental rights and responsibilities.
Surrogacy is one of those very decisive topics. I've dealt with it slightly in my dissertation. The difficulty, Commissioner, as you're fully aware, is what rights do you have? All you did was to say enter into a commercial agreement with a young lady that she will carry the kid for you. This young lady midstream decides no, she's not going to give up her child. She's the biological mother. And those surrogacy arrangements, and at the appropriate time I think I'll write a paper or two, are very decisive topics. In America, this has been the subject of raging controversy, which has gone up to the Supreme Court. Because you who gave the mother the money, you feel entitled as of right. But on the other hand, the biological mother feels, and she's perfectly entitled to feel, that this is the womb, the child of her flesh. So what rights are they? That is something that really one cannot be able to define with any accuracy, because for one answer, you get two different answers.
Senior Counsel, our courts have made some determinations around that subject, despite the fact that we do not have a formal legal framework to deal with those agreements.
Correct.
And I would just love to hear from you how, according to the decisions that have emanated from our courts, how, for instance, a prospective parent should go about acquiring the rights and responsibilities of a parent. For instance, how he should go about getting his name registered as a parent, which of course comes along with the rights and responsibilities of a parent.
Why I indicated that for one answer you get two contra answers, I'm aware of the case. Maybe there are more cases than one. I've been requested to give an opinion for purposes of going to the Court of Appeal. So I'll be a bit hesitant to go into it, but definitely what we can say, and here I think, Commissioner, you would agree, that is not the last word. That decision has not been tested at appellate level, and because of the constitutional underpinning of it, in case I were to go on with that brief, I see myself ending at the Supreme Court. So I'll be a bit hesitant to talk about it, but it is really not a last word on that issue.
Very well, Counsel. We can move on to the next question that I have.
Yes.
What are the Bangalore principles of judicial conduct?
The Bangalore principles, I do remember them. They are 6 in number. And these are for the judges and also for the judiciary. In the sense that judiciary is supposed to craft a code of conduct around those principles. Independence is one of them. I think the next one is impartiality. That is natural. Equality. The fourth would be propriety, how the judge holds himself, because how the judge holds himself in public and in private is so important. Then the next one is integrity. and then competence. And to me, if I could pause there, Commissioner, competence becomes so important, because to have a judicial officer who is incompetent is to put an aircraft in the hands of an unqualified person. And then the last one, I believe, is diligence. Diligence, and judiciary, and for that matter, JSC, would be able to craft a code of conduct around those principles, as I understood the paper that I read.
Thank you. You've actually moved on to answer my next question. I was about to ask you what is the legal status of the Bangalore principles.
Yes.
Maybe you can say something about that.
Yes, the legal status is that really this is something that has been agreed upon, and they are repeated all over, and judiciaries or JSCs are supposed to craft their code of conduct around them.
Thank you. Now that you say you did some reading around this, where and when was the idea of having the principles first conceived?
I think it's got a long history. There was a Harare Convention. Before then, there was a meeting, I think, in the United Kingdom. There appear to have been quite a number of meetings discussing this. I may not put my finger directly to the first one, but I could see this, a lot of engagement. And maybe even after Bangalore, there could be subsequent engagements.
Okay, thank you. This is a question that I have got from your introduction. You talked about being involved in some kind of framework, developing some kind of framework of the disciplinary process at the University of Nairobi when you started off. And I just wanted to ask you, because I imagine in your brief at that time, you may have encountered something to do with the subject of student activism or youth activism. What is your position concerning that?
Activism at that level is naturally expected. Youth activism is a phenomena that any university must expect. I also did a bit of work for our Catholic university. At that time, we had clergy who were in charge, and I had really to take the clergy through a process to tell the clergy, look, please remember the students are secular. They are not part of us. They are not part of the clergy. So it is something that we must expect. We can't expect anything less than youth at that level having some activism. What I find difficult to understand is how we as a university then react to that by being very insensitive and having disharmony in how we react to it. So a student found, for example, having done ABC, is expelled by one college, but for the same offense, he is reprimanded. You see, the minute, even for us as lawyers, we see disparity in the sanctions we get, you naturally getting counter feelings that no, so and so was favored because his father is rich. So activism, true enough, it was there. And I'm sure even during our times at the university, there was a lot of activism.
Thank you. Thank you very much, Senior Counsel. Now, my next question touches on matters that border on welfare and employee motivation. I'm sure you did quite a bit of preparation when you made up your mind to apply for this position, and even as you were coming for the interview. And in that preparation, I expect you may have interacted with some of the welfare concerns that the members of the judiciary have. Am I correct?
Correct.
Thank you. Now, we have a scenario that is causing a lot of concern, especially amongst the judicial officers. We know that under the Constitution, in terms of post-admission experience, the required experience is 10 years. By the time a member joins the judiciary as a judicial officer, as an RM, resident magistrate, they are required to have about 3 years experience. If he's lucky enough to get promoted at the next interview, but if again his lucky comes after 3 years, he would be having 6 years experience. By the time he's PM, if he's extremely lucky, he will have close to 10 years experience. When jobs for interview, or rather when jobs for promotion or appointment to the superior courts are advertised, of course the cutoff required experience is 10 years, just as is provided in the Constitution. But you will find this magistrate is still far below the hierarchy of ranks that is required to go through before he can ascend to the High Court. Invariably, members who should be promoted to the High Court will be picked from the Chief Magistrate level, so that by the time you even qualify for consideration, you will have pumped in no less than 18 years in this institution. Yet out there, shortlisting is done based on 10 years post-admission experience. This eventually also brings in another problem when it comes to the pay structure. Because after putting about 18 years in this institution, your level of pay may not necessarily be at the entry level for judges. But you'll have this fellow, maybe from private practice, after having 10 or 11 years experience out there, coming in and objecting to your higher pay. Those are issues we've been grappling with in the institution. So there is that concern that the application of the cutoff post-admission experience is applied discriminatorily. But then again, we have those challenges. Are we going to open it up for RMs to compete with chief magistrates for promotion to the superior courts? How are we going to address that challenge under your leadership? What creative interventions would you come up with that will satisfactorily settle this issue in a way that will be acceptable to all people on both divides?
Again, it's unfortunate this discussion goes insider and outsider. It's so unfortunate because if my view is allowed, I'll still go back to the word of merit. I would hate to ever hear a magistrate saying, if lucky enough, I was promoted. I would actually be doubly hurt to hear the phrase, if I'm extremely lucky, then I'm promoted. My promotion policy would be based on nothing but merit. Merit would be the only consideration, not luck. Consequently, it's important really that a peer review is in place so that a magistrate at court this and a magistrate at court that, this other one, you are able to independently verify how hardworking and meritorious are their output.
I'm sorry, Counsel, if my words sort of created a confusion. When I was talking about luck, I wasn't talking about people getting promoted on the basis of luck.
Okay.
I'm talking about luck in terms of coming up for determination for promotion.
Very well.
Yes.
Thank you. So, because it's merit-based, I would want to see a situation where when a magistrate has done 10 years or 11 years or whatever number of years, that magistrate has an equal opportunity with somebody in private practice to apply for a job, for appointment as a High Court judge. I would not want to hear or to wait until a magistrate is at the level of the chief magistrate to be able to say it's only at that level that you can apply. Because the Constitution defines it's 10 years, isn't it? So why is it we are putting other barriers because these barriers become a hindrance only to a segment of the population. For a lawyer, there is no hindrance that you must have done cases up to this level to apply to the High Court. It is the number of years. So, because of this belief I have in uniformity and non-discrimination, I can assure you, Commissioner, in my tenure, a magistrate who has the required constitutional qualification, given the work done, would have an equal opportunity with any other person. As a matter of fact, I'll look more towards magistrates going to the High Court because it's also part of developing a culture of this, a reward culture.
Thank you very much, Councillor. I'm sure magistrates listening to you out there are crossing their fingers for you, wishing you luck.
Thank you. Not that I would discriminate against advocates in private practice, but it's important that we do not discriminate against magistrates and then give a leverage to advocates in private practice. We must look at the merit and merit only for these judicial appointments.
Thank you. So now we can move on to your application.
Yes.
I noticed from the documents that, or rather the response we got from the vetting bodies, that you are not cleared by KRA, you are found to be not compliant. I just want to hear from you whether that, whatever issue that was there has been resolved, and if you can get communication to that effect that you have now been cleared.
I think, Commissioners, it's important I say this. Let this process also not have many other actors. I have a valid clearance certificate. Then I got communication from KRA that all candidates for this position must go there. I wondered why we all must go there despite our having clearance certificates. When my tax consultant went, he was told I have some penalties of 1 million shillings. I paid it, but I started seeing as if there is a third hand in this process. A week later, I was told, doing in-depth from 2015, there are some tax arrears. I have responded to it, and I have told Caesar that, Caesar, you are entitled to your lawful sums, but nothing more beyond your lawful sum. We have agreed to do an ADR under the Act, and I have every intention to pay whatever is due. But I hesitate to say this. Do not let this process also have any other player. I was quite alarmed about being told to go there despite having a valid clearance certificate. But to answer your directly, yes, we are at ADR, and I've made every provision to pay whatever may be outstanding. For advocates in private practice, we have certain distinct disadvantages. You are holding funds for a client for purchase of a property. The client tells you put that money in a fixed deposit account. Once money is in a fixed deposit account, after 3 months, the interest is generated. And from that interest, there is a withholding tax. That withholding tax is paid directly to KRA. For KRA to assume that the money on interest is your income, and therefore expect me to pay income tax and VAT, you tell them no. It doesn't. Income which is not legitimate, then it becomes rather difficult to explain where that income has come from.
Thank you.
It's important for public officers to be able to be held to that very high standard. And I saw that in the Judges and Magistrates Vetting Board. The need for everything to tally. It's a tarrying process. And it's a...
With you in charge, despite your relationship.
Very good. Can we now, because this is the third time I've been asked this question, look at it from a different angle? It is true ICJ raised it, it's true Atheists Kenya raised it, but why is it that political formations are not raising it? Why is it that people who ought to be afraid if I was that associated are not raising it? There are so many emerging political formations I have engaged against in this country. So many of them. But they do know of my independence. They do know of my fidelity to my client. Each one of them knows that with me, I have nothing but fidelity to the work I am doing. Consequently, no political player, as far as I know, has said under Ngatia there will be no independence of the judiciary because of its association and so on. Because they know there is no that association. My fidelity will be to law. I have no preference in whatever happens in the political process. I have no preference to any case of any person against the other. I will simply be a Chief Justice who would do nothing but administer pure law. And that is why, Madam Commissioner, you see the 2 or 3 or 4, they all start off, it's so predicated or prefaced. We know Ngatia is a very professional lawyer. We know Ngatia is a very hard-working lawyer. All of them. And I'm sure that is the common parameter with all of them. But then they say, could he explain? He will not be. And really, as I indicated, Kenya is beyond what is the current political dispensation. If I am appointed Chief Justice, if I have to do 4 or 5 years or 3 years, it will mean that I'll do it under 2 presidents. Consequently, I do not think, and I say this without any fear, I do not think any well-informed Kenyan sees me as an extension of the 4th President of the Republic of Kenya, because I'm not. There is no well-informed Kenyan who sees me as being compromised in any way by the 4th President of Kenya, because I am not. If you look at my CV, Madam Commissioner, you see from 2013, the cases I have done against government institutions. The cases I have also done for the government. And all those show a fidelity to law. For example, when TSC, my client TSC, was told to pay teachers a very hefty award of money that would have collapsed the economy, TSC came to me. And they came to me directly, not through the proxy of anybody else. And I did that appeal in the Court of Appeal, and I won on merits. Similarly, any aggrieved person by any arm of government, again is in my CV, you see I acted for him with the same zeal and the same diligence. Why? Because I practice pure law in my practice. That, I think, is what Kenyans have known me for. In my CV, you see from many, many years ago, I have only worked very hard for every case I have acted for. Whether I lost or I won, it was because of the hard work I did. And there's no lawyer and there's no person who will tell you that I was a political project of anybody in this republic, because I've never been.
Thank you very much, Senior Counsel. Kenyans have heard you. I've heard you. Thank you for being patient this afternoon. I wish you well.
Thank you.
Thank you, Chair.
It has been a long day. Commissioners and Senior Counsel want to thank you. So this is the end of this interview. Thank you for coming. Senior Counsel, thank you for your very honest and exhaustive and even passionately answered questions. We want to thank you for that. And on behalf of my fellow commissioners, Senior Counsel, wish you all the best. Do you have anything to tell the commission?
Yes, before you conclude, Prof.
Yes.
What I did, because Kenyans need to be told that a lot of good work is done in Attorney General's chambers, because it's so easy to condemn government agencies. I came with a map of Ilemi Triangle, which shows the area that we won for this country, which measures 9,680 square kilometers. This is the Ilemi Triangle. In this area, we have 2 constituencies. We have now established a lot of infrastructure, and all this was done under the guidance of the Attorney General, and the person who ought to get all the accolades is the Attorney General. I was only a faithful servant of the Attorney General. But what I've done is to prepare 9 copies for all of you. It is an important milestone, and this is to show that in whatever areas of our human activity, what matters is the diligence, the persistence, and the determination. With that, you can achieve anything in this country. I do not know of any other country in the world that has won as much territory as that, but there are many cases in my research paper that have indicated cases between Norway and Sweden, where the same principles of law were applied, and those principles of law have enabled me to come to that conclusion. In other words, Prof, there are indeed Kenyans who are dedicated to this country and who work for this country and work for this country relentlessly, independent of any other consideration. My last word is to say that this has been a wonderful session. I do not know what to say. I expected nothing less than what I got. It is a very invasive process. I didn't expect to be the subject of so many complaints by so many people about having conducted an election petition, which I conducted in open court in the Supreme Court. But there you are. The appointment of a Chief Justice is not an easy thing. It's done by the 3 arms of government, by Judiciary, number 1, by the Executive, and more importantly, by National Assembly. So I am thankful, and you've treated me quite well.
Thank you, Senior Counsel, and thank you for this information, because a lot of us, personally, I didn't know about this, and I'm sure fellow commissioners, some of us didn't know. So thank you and even Kenyans. So it's good you brought it to attention, and thank you for that work you did for the country. Yourself at the AG.
Yes,
thank you. The best. Thank you.